Our next speakers here today are going to tell us about the federal, state, and local issues impacting real estate. We have one of NAR's lead attorneys here to update us on the status of the DOJ's settlement agreement. So please join me in welcoming Lesley Muchow. Lesley Muchow is the Deputy General Counsel and Vice President for Legal and Antitrust Compliance at the National Association of Realtors. She's been with NAR since May of 2010. Her focus areas include the Americans with Disabilities Act, employment law, fair housing, and NAR's constitution and bylaws and general contract negotiations. Quite an extensive portfolio. Lesley, thank you so much for being here with us today.
Thanks, Ryan, and thank you for inviting me to join your program to provide an update on the DOJ action. As many of you know, or likely know, the NAR reached an agreement with the DOJ related to the Department of Justice's questions about the MLS system and commissions. This settlement resolves the Department of Justice's questions and requires that certain rule changes take place. While NAR's rules have, of course, always sought to create an efficient and competitive market for home buyers and home sellers, the rule changes that will come as a result of the settlement will more explicitly state what is already in the spirit and intent of NAR's Code of Ethics and MLS policies. I'm going to go over each of the rule changes that are required as part of the settlement, but before I do that, I do want to underscore a few things about the settlement. First, there's no immediate action to take. There are several steps that must take place before any of these rule changes can go into effect. The court in this action has to approve the terms of the settlement, and it will do that by entering its final order, which essentially blesses the settlement. The settlement also requires that the proposed rule changes be approved by both the Department of Justice and NAR's Board of Directors. To that end, just last week, we provided our draft proposed rules to the Department of Justice for their review. And we will continue to engage with the DOJ until we reach an agreement with them about what those proposed rules look like. Then those proposed rules will be provided to the NAR Board of Directors for its review and approval. NAR disagrees with the DOJ's characterization of NAR's rules and policies in this action. And so as part of the settlement, NAR is not admitting any wrongdoing or liability, and we are also not required to pay any fines. So we really believe that this is a positive outcome because not only will it bolster the core tenets of MLS policy, but it also helps avoid protracted litigation and expensive litigation so that we can remain focused on what our core mission is, which is to help members and support members in providing their services to consumers and advancing the dream of homeownership. So let's talk about what we all want to hear, which is what are these rule changes? So in a nutshell, the settlement requires 4 rule changes. First, that the offer of compensation be disclosed. Number 2, real estate transaction services cannot be advertised as free. Number 3, MLS listings cannot be filtered or restricted based on the offer of compensation or the name of the listing agent or broker. And 4, lockbox access must be available to all real estate licensees. So now I'm going to go into a little more detail about what these proposed rules will look like and how we intend to implement them. So first, as I said, the settlement requires that the offer of compensation be disclosed. So we propose to accomplish this by adopting a new MLS policy statement. And that MLS policy statement would first prohibit MLSs from prohibiting or discouraging the display of the offer of compensation by MLS participants and subscribers. This would require, for example, if the MLS maintains a publicly facing website, that website display the offer of compensation. It would also require that MLS listing sheets that are provided to consumers also disclose the offer of compensation. The policy statement would allow MLSs to require that a disclaimer accompany that display of the offer of compensation to clarify that the offer is being made only to MLS participants. And then finally, the MLS policy statement would require that the offer of compensation be disclosed to clients before an offer is made on that listing. In addition to this new policy statement, the VOW and IDX policies will also need to be amended to explicitly state that the offer of compensation field cannot be designated as confidential. Next, members will be prohibited from advertising their services as free or available at no cost. You probably already know that this prohibition exists in the Code of Ethics Standard of Practice 12-1, but here the Department of Justice desired further clarity. So we're proposing that a new MLS policy statement be adopted and Standard of Practice 12-1 be amended to expressly state that real estate transaction services cannot be advertised as free or available at no cost to clients. Here, the use of the word client is important because it is our intent that this rule change prohibit the advertisement of services in connection with a real estate transaction as being free or available at no cost. Our intent is that members continue to be allowed to provide complementary services such as CMAs to prospective clients, as many do. Next, the next rule change is about the filtering of listings, and that would restrict the ability to filter listings based on the offer of compensation or the name of the listing broker or agent. So we know that Article 1 of the Realtor Code of Ethics has a duty of realtors to act in their client's best interests, which means that all listings that meet a client's needs or desires or stated parameters should be presented regardless of the offer of compensation or name of the listing broker or agent. So this rule change would simply affirm that duty and again restrict and prohibit MLS participants from filtering listings based on the offer of compensation or the name of the listing broker or agent. Here again, the IDX and VOW policies would need to be amended to eliminate the ability to search or restrict the listings based on offer of compensation or the name of the listing broker or agent, and also to remove the ability to filter based on level of service or membership, because those last two could be used as a pretext to circumvent the rule's prohibition on restricting filtering based on the name of the listing agent or broker. And then finally, with the seller's permission, all real estate licensees must be eligible for lockbox access. So before I dive in on this one, this rule has definitely garnered the most attention and questions and concerns. And it's helpful to remind members that there is an existing duty under Article 3 of the Realtor Code of Ethics. And this longstanding duty, duty to cooperate, would already require realtors to provide information or access to properties to other brokers, regardless of membership status, when it's in their client's best interest. Current MLS policy leaves it to local discretion as to whether or not temporary codes can be issued. So MLS policy here would have to be amended to require that lockbox providers enable temporary codes. And the good news is that Central Lock and Supra already have this capability. The proposed rule, as I said, has garnered the most attention. And so I really want to underscore that it's our intent to craft a new rule that would allow members to comply with their Article 3 obligations, as well as the rule, in a way that has safeguards, structure, and as I said, safeguards in granting lockbox access. So here, all active real estate licensees with a license to practice real estate in the state where the property is located must be provided lockbox access. Licensees can be required to provide evidence of their active licensure to confirm that they are in fact active licensees. They can also be required to execute a lockbox agreement, the same lockbox agreement that other participants are required to execute. and they can be subject to the same security precautions that every other participant is subject to. So for example, the MLS or association has a policy that all applicants must undergo a background check in order to gain access. This licensee could also be required to undergo that background check before access is provided. Then finally, the licensee can be charged a reasonable amount for lockbox access. You'll want to work with counsel in determining what that fee is, and it really should never exceed what is charged to other subscribers and participants. So those are the required changes and how we plan to implement them. And I say that because, as I said in the beginning, these are still draft changes. No immediate action is required. The court still has to enter the final order. We still have to get the DOJ and the NAR Board of Directors approval. Right now, the court is in what's called the Toonie period, which is a 60-day period where the court can receive comments on the settlement. Once that ends, which will be in mid-February, the court will be free to enter that final order. A Board of Directors meeting will be held, as I said, sometime in the spring, so that the proposed rules can be presented and approved. And so nothing will take place or change between now and then. I do want to point out that NAR has a dedicated landing page on the DOJ action, and I encourage you to visit that page. You can link to it right through the homepage of nar.realtor. It has a lot of background information, FAQs that will help answer some of the questions you might have, but also please feel free to contact me with any questions or feedback. I also want to highlight a new resource about Article 3, which I mentioned during the lockbox access rule. And that Article 3 resource underscores exactly what I said here, which is that Article 3, the duty to cooperate, already requires realtors to provide information and access to properties when it's in their client's best interest to other brokers, regardless of membership status. So I encourage you to look at these resources, use these resources, and in the meantime, again, please feel free to reach out to me. We've heard from many members and associations. We've gotten a lot of great questions and feedback that has been very helpful as we work through this rulemaking process. And we want to make sure that we implement rules that are in the benefit of our members and consumers. So thank you again, and I hope you enjoy the rest of the program.
Lesley, thank you so much for your time today. I know this is an issue that so many of our members were eager to get an update on, so really appreciate your time.